Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to themurthy.com. From the beginning, Murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The Murthy.com site provides you with latest and cutting-edge information on the US immigration law and policies, explained in terms you do not have to be a lawyer to understand. Today's topic is H-1 visa updates. We will continue the knowledge session along with the Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Murthy. Before we get on to the topic, do we have any latest immigration updates this week?
Hi, good afternoon, everyone. Good evening to those who are, I guess, in India. I know it's very late for you at night. No major earth-breaking update other than the USCIS clarification just from yesterday that the I-693 medical forms, which they required the medical doctor to use the September 13th, 2021 form, if the medical doctor met with you and signed after October 1st, is required. But before that, it was not clear if you had to go back to the doctor if you'd got it done a couple weeks ago. But now they made it clear yesterday that the only thing you need is if the doctor signs it on or after October 1st of 2021, then they have to use the September 13th version. And they only announced that 2 days ago. So people were getting very upset about it. So some peace of mind that if the doctor signs it, then you have to ensure that they have to redo it and give it to you on the latest form. Otherwise, the entire package could potentially be rejected, or you may get an RFE, which will cause a delay in your approval if it's for the 485 or green card, etc. So I know you wanted to start on H-1B processing. Should we get started with that first, or just on the process? I know we're expecting the same pre-registration to continue, like in the last year or two, since 2020. The people who are selected will then have, if this pre-registration happens like this happened this year in March, next year of 2022, then you have April, May, and June to pretty much file the petition. And then this year in 2021, they had a second lottery. So a handful of people, much smaller number, were able to file July, August, September. So they had the second quarter. And I say that because, as many of you know, the fiscal year for USCIS starts on October 1st and gets over on September 30th. So the pre-registration for the H-1B lottery starts in March. And then usually you can file April, May, June, and now July, August, September if it's in the second lottery. But other than that, the law itself has stayed pretty much more or less the same.
Right. Ms. Murthy,
so that's a quick overview.
Right. Ms. Murthy, we have a caller waiting, Mr. Vinay from Texas. Thank you for calling, Vinay. You may ask Ms. Murthy your question directly.
Hi, ma'am. This is Vinay. I have a question. My son is 15 years, and I went for the downgrade in last October, EB2 to EB3. So my date is current in EB3 and as well as EB2 also for this month. So EB3 downgrading application 140 is still pending. So my son date is locked, or if it is goes a retrogression, then what about my son says? Is it a freeze, or 140 need to be approved before freezing?
Well, the USCIS obviously, Vinay, cannot approve the I-485 adjustment of status for you or any of your family members unless there is an underlying I-140 that is approved. Now, generally, they would have just used the EB2, but because you downgraded it and filed it last October of 2020. So until that is approved, they cannot approve the 485. Now, the one thing USCIS had mentioned was that...
What I'm saying is my son's age is locked, or once it approved, after 1 month or 2 months, and what about my son's age? Is it a 15 years or,
Approval has nothing. Vinay, approval has nothing. Approval of the I-140 does nothing to the age of the son, okay? The approval, the time that it is spending is subtracted from the child's age. So approval of the I-140 does not protect or freeze the age or do anything. It's just the time that it's spending that CISPAR, Child Status Protection Act, gives the credit of that time to the child that is using that EB3 application, adjustment of status application, to file what it is. From what little USCIS has explained, because there was a change in policy in October of 2019, just 2 years ago, where they said that even if the 485 is filed, if the final action date is not current, the child is not protected. Now, once the final action date, priority date became current, like for you now in EB2 and EB3, Vinay, in both categories, technically, according to that USCIS interpretation, your child's age should be frozen and stay frozen, even if down the road there's retrogression. But that specific sub-issue or wrinkle has not been 100% clarified by USCIS. All they said is, if the final action date becomes current, then the child is protected, and CSPA will protect and freeze the age of the child. So the argument, of course, to make is that, hey, age is frozen. It cannot freeze and unfreeze, because Congress, the US Congress, the US legislature passed CSPA to protect children, to keep families united, and to ensure that the family union is together. So that has to be the argument, but it's not 100% crystal clear answer, Vinay.
Right.
Thank you.
Ms. Murthy, do you want to discuss anything further about our updates, or should we move on to the questions?
If there are more questions, we could certainly move on to the questions. But with respect to H-1Bs, so we have started again seeing a few specialty occupation RFEs, whether the person's education is directly connected to the job duties. They have not started issuing what we had seen for the last 4 years under the prior Trump administration, with questions that almost broke the law and violated the law and the regulations by asking for items that were clearly resolved successfully for the last 20, 40 years, started being asked, but we have stopped seeing that. But now again, we have seen a couple of specialty occupation RFEs, qualifications, salary-based, education-based, direct connection between the education and the job duties. So you always have to prepare a case as rock solid as possible in advance, so it won't come back to haunt you or result in the worst case, a denial, or even ideally you want to avoid even an RFE if possible.
Right. Ms. Murthy, we have a caller on hold, Mr. Kumar from Chicago. Thank you for calling, Kumar. You may ask Ms. Murthy your question directly.
Hi, ma'am. My name is Kumar. Actually, I have two questions. One. So my priority date is June 2013, and submitted my 485 with medical, and I-140 approved in EB3, which is a straight EB3 for me. And biometrics is done on 16th September 2021. So I just want to know, my two questions is can we expect any updates on my GC before November 1st EB3 retrogress? And one more question is, so I want to know what is the actual process after biometrics when I'm given my biometrics after 16th September, and what happens after that? It goes to FBI for my clearance, and it will take some time, how many days it will take, or months, or any idea on that? And after that, it's going to update to USCIS. So I want to know the process, a flow, how it goes. These are two questions for me.
Okay. So Kumar, what did your company lawyer explain to you till now? What have they explained? What is the possibility?
I didn't ask anything. Just it was a straight EB3, but I want to ask like whether we can expedite anything from my side, because I am expecting my date is going to retrogress in November. I'm hoping that before that I can get any update on. So I want some advice from you.
Yeah, so the USCIS will not expedite just because dates are retrogressing. That is not a reason to expedite. Expedite, if you look at the law and look at the criteria, you can go to uscis.gov or murthy.com. You will get the information on what is the new expedite criteria that was issued last year by USCIS. It has to be severe humanitarian reasons. It has to be extreme benefit to some serious, like sometimes for Child Status Protection Act, children aging out, like the previous caller, Vinay, that potentially could be a reason. But now the child is only 15 in that case. So even that's not going to work. But if the child is going to become in the next 6 months, 21 years old, then you can certainly push it, or the employer will suffer severe economic hardship. Something where we can show the disadvantage to other future jobs, to the economy, to the United States, rather than, hey, I want it because the dates will retrogress. Kumar, the USCIS doesn't unfortunately give that the weight that, of course, it is your life, and of course you have every reason to want to get it ASAP, because of course you want it. You've been waiting for probably years and years and years, but the USCIS does not give that, consider that an expedite criteria. Now, very often we have seen where if they've got everything concluded, they've completed the security checks, the fingerprint, like in your case, medicals are done, everything. Even if the dates retrogress, they can approve the case during the month of October, even if you get the actual approval notice in November or even in December when the dates may be retrogressed. And by the way, there's no guarantee that the dates will retrogress, Kumar, just for the record, because that's what we think could potentially happen, but we don't know how far back that will go. But even if it does, we have very often seen where USCIS will use up as many of the immigrant visa numbers as they can month upon month, because there are multiple lawsuits filed against them. They know that they are getting pressure. The quality of service, in my opinion, has continuously gone down, has been downgraded and degraded rather than becoming better after fees have continuously increased. And so I've often said, if any private business ran like that, we would all be shut down. But because it's a government bureaucracy and because they can ask more fees for service that I'm not sure is worthy of that much high fees, they are continuing to operate, because where else can we go for our approvals, right? So no, you can't ask for you can ask for it, but they probably won't give it to you, Kumar. But you can just request it and say that I have been waiting and here's the dates. Please, can you expedite? They'll probably turn you down. But if nothing else, if they look at the case and everything else looks good, they could very well decide to approve it. That's within their control. Good luck, Kumar. I hope it works.
Right. Ms. Murthy, as long as we're on the expedition topic, I mean, what are the ways one can expedite their H-1B visa process?
So for all expedite criteria, it really has to be based on severe economic hardship to the employer, severe impacting of the U.S. economy, extreme humanitarian circumstances, or the USCIS own error, government error that caused the problem in the first case. So if you say it's USCIS error or any of these other 3 reasons that I gave you, any of the 4 reasons I just explained, then you could certainly request expedite. Now, expedite is completely different than premium processing program, where you pay that extra fee to get a premium process case approved.
Right. I was going to ask that question before and you answered it already. So moving on to the next question, when can a person file their H-1B visas, and is there a good time perhaps?
So is it a cap subject petition or a regular extension with the new employer?
H-1 visa or a cap? Could you tell us both, please?
So for cap subject petitions, it's what I explained before. You file it pre-registration, you get selected, and then only those who are selected are allowed to file in April, May, June, or if you get picked in the second pre-registration, then July, August, September, right? On the other hand, if it's just an extension because you're changing from one H-1B employer to another H-1B employer, then that's a totally different, because you could do it anytime. If you're already counted in the cap within the past 6 years, you're allowed to switch jobs anytime. if it's if it's a cap subject employer. Of course, if it's a cap exempt employer, then also you can file it anytime if you were never subject to the cap and you want to switch from one university to another university or one hospital affiliated with a university to another one, etc. So that's the way the process works. We've gone over a lot of the RFEs and situations, the problems that people were facing, unfortunately, in the last 4 years. And we're hoping that it'll be much more reasonable and fair. We've already seen many fewer outrageous RFEs like we had been seeing that technically were a violation of the law. There were multiple lawsuits, but not everybody has the time and the money to keep on filing lawsuit after lawsuit after lawsuit against the federal government. Then they make mistakes or they do something that's in violation of the law, or that's something that's not even permitted under the law, or they stretch the law in a wrong way. So people sometimes have just left the country because even after living here 10-15 years, because USCIS was denying simple H1 extensions.
Right.
Thank you.
So, could you explain to us the H1B labor condition application, the LCA?
So for the H1B, before you file any H1B, the employer has to file a labor condition application where they have to obtain the prevailing wage for that position based on where it's located and the nature of the job duties, the complexity of the duties. What is the minimum required for the job? Is it a bachelor's degree or master's degree? Does it require 0 to 2 years experience, 2 to 4 years experience, 5+ years of experience, or 8+ years of experience? Because obviously the number of years of experience for the job duties will increase the salary. Level 1, level 2, level 3, level 4. There are 4 levels of wages that are generally used. Plus, if a job obviously in a place like New York City or San Francisco, the salary is going to be much higher than, let's say, a place like Des Moines, Iowa, or a smaller town anywhere in the United States. So once you get the prevailing wage, you then submit it electronically to the U.S. Department of Labor, and it is supposed to be pretty much certified as long as all the columns are correctly filled, the wages checked off as from the Department of Labor, or if it's from other private surveys that you're using. But whatever the reason, once it's certified, you then include it with your H-1B petition filing to go ahead and get the petition approved. Remember, for H-1Bs, you have both the Department of Labor through the LCA and the Department of Homeland Security through with the USCIS that is involved in approval of every H-1B petition case. And if you're abroad and you have to apply for the visa stamp at the consulate, then on top of that, you need the US Department of State through the US consular officers that have to approve and issue the visa, grant the visa in order for the person to be able to enter. So then you deal with 3 different federal agencies: Department of Labor for the LCA, Department of Homeland Security / USCIS for filing and getting the petition approved, and US Department of State through the consular officer that approves the H-1B visa stamp in your passport. I hope that was a good big overview of the different agencies involved.
Overview. I was going to say that our viewers are going to be so thankful for how vividly you explain everything. And we have a caller on hold, Ms. Murthy, Mr. Prasad from New Jersey. Thank you for calling, Mr. Prasad. You may ask Ms. Murthy your question directly.
Yep. I'm calling from a company. You have a question that I have an employee who's been with us for almost 3 years. We have filed 1 extension with him, and he went out for a full-time job. After 3 months, he wants to come back. So I just wonder, what do we open on the LCA, and what is the phase for the H-1B now?
So I'm trying to understand, did you revoke the prior H-1B, Prasad, that you had for that employee? Did you revoke it or did you not revoke it?
No, we have not yet revoked it.
Okay, if you have not revoked it, you don't need anything as long as you get the, if it's in the same work location, same job duties, same employer, same employee, same everything, then you can just use that H-1 petition and show that the employee was not ready, willing, and available during the 3 months because the employee had gone to some other job. But if everything remains unchanged, you don't even need a new LCA, you don't need anything. The employee can just use that H-1 petition. But if everything has changed, then you need to file a new, if there's a new job duties, new work location, new client, etc., then you have to file a new LCA for the new work location, as well as file an H-1B amendment. And as long as that petition is filed and pending with USCIS, he can join you and continue because the underlying H-1 is still valid as long as you file it before he starts work in the new work location, Prasad.
Right. Ms. Murthy, H-1B visa is also sometimes referred to as dual intent. Why is that?
Oh, so when the Immigration Act of 1990, IMACT, they call it IMACT 1990. I can't believe that was 30 years ago. Feels like the other day. When Immigration Act 1990 was passed, for the first time in the history of US immigration law, they introduced a new concept, the concept of doctrine of dual intent for only two visa classifications, H-1B and L-1. That's it. Those are the only two classifications that are that enjoy the benefit of dual intent. What does dual intent mean? Dual intent means you can have two intentions at the same time. A non-immigrant intent or intention that if I want to go back to my home country permanently, I will leave the US, and an immigrant intent that if I like it here, I will file my green card and stay forever. And as long as it's an HL or their dependents on H4 or L2, no problem if they tell the consular officer, I'm going to settle down there. But other visa categories like F1, student visa, or B1, B2, tourist visas, J1, those are considered pure non-immigrant visas. If they suspect that you may settle down in the United States, they have the absolute right.
I'm extremely sorry to cut you in between, but Prasad is still online and he has another question to ask you. Hi, Prasad.
Okay.
Hi. So on the LCA, should I use the amended petition because the concern is the same MSA, but the client has been changing and the job duties are changing. So shall I just use amended petition or can I use continuation? Shall I use amended petition?
So Prasad, as was explained at the start of the show, it is not legal to give case-specific advice because what if there's some exception or some rule? So it's possible sometimes if it's the same MSA to go ahead and use it, but in general, I think it's way safer for you, for the employee, everyone, sometimes just to file an amendment, to put the new location and file an H-1B amendment, because if the FDNS officer, the Fraud Detection and National Security, comes to the work site to investigate whether the employee is working in that work location and they find nobody there because he's obviously not going to be at the prior client site, then it could raise a red flag and the USCIS may issue a notice of intention to deny or annoyed, denying the whole case, in which case then you would have to respond saying, no, it's within the same MSA and here's the law and here's what the regulations, and you could fight it. So as long as your company lawyer and you are willing and you understand what's required and you're willing to go the whole 9 yards, you could potentially just continue or file a new LCA with the new location and do a new amendment, an H-1B amendment. And as long as it's pending, even if it sits there for 1 year, 2 years, 6 months, you don't care because the employee is allowed to start working from the day that you file it, Prasad.
I hope that answered your question.
I don't know if you also
Prasad.
asked about fees. Yeah, I think he was also asking about fees and process, but
fees, yes.
Please feel free to contact the Murthy Law Firm client service or the email because we have very, very reasonable fees. People are always shocked because they assume if you go to a 5-star hotel, you should pay 5-star prices. But our goal and philosophy and our vision and mission statement and values is all about helping people to do the best possible work at the best possible fee to make it very reasonable and affordable for employers, employees, individuals, families to work with the Murthy Law Firm. So in terms of fees and processing, a lot of times people have even said to me, oh my God, I didn't even ask your fees because I assumed they would be so expensive. And actually you're $500 cheaper than my current lawyer who's just messed up my whole case. So in life, if you don't ask, you won't know, right? So please feel free to contact either law@murthy.com or call the office if you prefer talking on the phone. Or we even have live chat available during normal business hours. We have somebody available to answer your questions. So whatever it is, we'd be honored to help you, your company, your business, your family, your friends, anybody with respect to any immigration law matters. Good luck and thank you, Prasad.
Right. So, Ms. Murthy, you were telling us about dual intent. Please continue.
Oh my God. So this is not a recorder. The brain has to stop and restart, right?
I can
So we were
help
just
you. I
talking
mean, you
about
were
the
telling
different
us
intents.
about non-immigration and immigration, the intent to stay
Yeah.
and not.
Correct. So H1 and L1 and their dependents, L2s and H4s enjoy it. Pure non-immigrant visas like student visa, tourist visa, J1s, etc. So almost all the other categories are considered non-immigrant visas, except that there's some that are kind of quasi-dual intent. Sometimes they look at O visas or journalists, the I category, sometimes, or TN, the NAFTA, under the US, Canada, Mexico agreement. Sometimes they consider those quasi-dual intent, but the law only has two that are clean dual intent, that are H's, L's, and their dependents.
Right. So, Ms. Murthy, when you said in the beginning of this question, I mean, when you were started to answer, that dual intent was earlier only allowed for certain jobs, I couldn't help but wonder if, dual intent still stands for probably just certain jobs, or maybe there are certain jobs that H1B, certain people who work those jobs who would probably not get H1B that easier in comparison to others. Is there any possibility like that?
So the consular officers, the U.S. Department of State, the U.S. consular officers, when issuing the visa, or even USCIS, has, as I told you, specialty occupation, does your education match? As long as the job is complex, sophisticated, and requires at least a bachelor's degree to perform, if it's in a specialty occupation and you meet the legal criteria and test in order to qualify for an H-1B, then it shouldn't matter where you work, what kind of job you do, etc. But as a reality, what we see is that consular officers may say, oh, that's not so complicated. You don't need a bachelor's degree to do that. Are you sure you have a bachelor's degree? And you know what? You have a bachelor's degree in mechanical engineering, but the job is in computer science. So you need a computer science or information technology or electrical engineering, maybe. So they start giving people a hard time on the kinds of education, the nature of the job, the sophistication, requiring a degree to perform that job. And then if you try to show a combination of education and work experience to qualify for the job, then it still is way harder, because the USCIS does not like what we call combination of education and work experience to satisfy the H-1B criteria.
Right. So it really just depends on the combination factor then. Right. So
Exactly.
Okay, so I'm going to conclude the show, but before I do, I want to ask what your golden immigration message to our viewers is.
So I know every week you ask me for this, and every week I'm always taken aback, because nobody else that I have done this with is so sort of big picture visionary thinking, and thinks of how can we share some type of a golden rule. So since a couple of the callers earlier in today's call, I believe Vinay and Kumar both asked about expediting their approvals. My golden rule in life is you lose nothing by asking, as long as we ask in a polite manner, with deference, and request what you want and explain and say it, because and say it in a way that the other party that is listening to it, the USCIS officer or the consular officer, etc., can relate to you on a human and humane level. I always say at the end of every single request, we have human beings. And as long as we can touch each other with our heart, because we care deeply, and we ask in a nice, polite manner, can you please expedite this for the following reasons? Even if they say no, they might think, oh, we really would like to make this. Can we make an exception and do this for this particular case? As opposed to even a good case, if sometimes you ask it with a bad tone or with a bad attitude, you will never get what you want. And that doesn't only apply to immigration issues, right? It applies when you speak to your husband or wife, to your children, to your employers, to your co-workers, to your employees, and to everybody in life. So what do they say? You can always catch more bees with honey than with vinegar. So always ask what you want in life, ask it with a good attitude, whether it is in immigration filings or in life, and you will watch magic happen in your life. So my golden rule for this week is think positive, visualize that you're going to get the approval, ask it in a kind, gentle, and caring manner, and watch magic happen for you. I really hope this was helpful again. Thank you for this opportunity. Have a wonderful afternoon if you're in the United States, and a good night to those in India. Take care.
And to you, Miss Murthy. Thank you. You're watching Sakshi TV live with me, Torni Makana. Thank you.